Welcome to The State of Us. Real people with honest opinions and the future of responsible media. Here's your host, Justin T. Weller.
The United States Supreme Court says that the Constitution does not bar partisan gerrymandering. That's in a 5-4 decision along partisan lines, or ideological lines if you fancy. So we're going to look at why you care about this, and we're going to pull back a little bit. So you've got this decision, brings up this topic of gerrymandering again, and the importance of what the court said here in how it relates to gerrymandering. Because there is a difference, believe it or not, between saying the Constitution does not bar gerrymandering and saying that it permits gerrymandering. So we'll briefly touch on that before we talk about this larger issue of what should be done about gerrymandering. Is it as simple as it seems? Just say, we don't want that anymore. But we can't begin this critical conversation without
your friendly redneck liberal, Lance Jackson.
Yeah, I've always had trouble with this guy, Gerrymander.
Yeah? You don't like gerrymander?
I don't like Gerrymander.
Okay.
Yeah. If anybody's out there named Gerrymander, I haven't met you, but I'm talking about this specific guy.
Hey, I tell you what,
Gerrymander.
I think we have a good omen for today. Our producer today, who is not Caleb Spinner, we've got Bradley today. He's on it, man. Did you see how quick he was on the redneck liberal thing?
He was, yes.
He was like,
he gave it right to me.
He said, I'm ready for it.
I
See,
know.
Caleb's getting lazy on us. He's like, me?
Oh, what? Huh? Yeah.
I got to cue Lance. So, a little bit here real quick about what exactly is going on. So this was a decision from a Maryland case, number 18-726. And it was...
Oh, that one.
Yeah, that one.
Okay.
It was brought by...
I thought it was 2-7, but it was 2-6? Okay.
It was brought by Republican voters who said Democratic state lawmakers had in 2011 redrawn a district to retaliate against citizens who supported its longtime incumbent, Representative Bartlett, a Republican. That retaliation, the plaintiffs said, violated the First Amendment by diluting their voting power. And then the case, Rucho versus Common Cause, number 18-422, was an appeal from a decision in August. Okay. So this is more recent, in August, by a 3-judge panel of a federal district court in North Carolina. The ruling found that Republican legislators there had violated the Constitution by drawing the districts to hurt the electoral chances of candidates. Mm-hmm. So what did the Supreme Court say about that appeal to the Supreme Court? They said, quote, according to the Chief Justice, we conclude that partisan gerrymandering claims present political questions beyond the reach of federal courts, end quote. This is according to the New York Times, June 27th. So what's the significance of this? Because this is a little bit like, Lance, what's going on with the Mueller report. I mean, not nearly as political, hopefully, but in that the nuance of what's being said, I think, is important to people appreciating the issue. We don't want to get into parsing the court's decision today, but I do think that making sure people understand what the decision actually means is important. Well, it'll be interesting to see how this is tested in the coming months in other states, in other cases. But for example, Lance, here in our great state of Ohio, a year or two ago, the citizens of this state decided to pass an amendment to the Constitution that made it so that gerrymandering basically they were trying to eliminate it by putting in a constitutional amendment that required a bipartisan group be used to draw the new district map from now on. So the Constitution of Ohio now has a stipulation basically about gerrymandering. This, right, the Supreme Court says, well, the U.S. Constitution doesn't prevent gerrymandering. So does that mean that Ohio's in violation? My non-legal interpretation of this is no, it doesn't. Because, right, the federal Constitution reserves rights not herein to the states. And so the state has the right, because the court also didn't say that you have a right to gerrymander. It's just saying the Constitution doesn't prevent this. So if a state does it, it's not in violation of the federal Constitution, but that doesn't mean that the state can't say they don't want to do it. And this is where it gets a little complicated.
But that's where we disagree, because I'm going to say then if I want the ability to gerrymander, then I can go to the Supreme Court and rule that Ohio's law supersedes federal law and a state can't do that.
How
without there being repercussions?
Because again, the decision is that the Constitution doesn't prohibit gerrymandering, not that it guarantees that you have the right to do it. Because the argument, right, that was brought before them is under the First Amendment, we're saying that it dilutes our voting, our right to vote per se, by misconstruing these districts. And the court is saying, no, that's not what the First Amendment is dealing with. So the Constitution itself is not preventing gerrymandering, but that doesn't mean that, for example, Congress couldn't make a law that says you can't gerrymander. Now, the Supreme Court then might have to re-examine that and say, well, is that law in contradiction with any other part of the Constitution? For what it's worth, from a personal standpoint, I thought the First Amendment argument was a little flimsy, and that it was definitely, because it's definitely not spelled out anywhere, just to be clear with everybody, right? There's no place specifically that says you can't gerrymander. Now, part of that may have been there wasn't a term called gerrymandering back then. But at the same time, there's not a part that is really clear in you cannot do this thing that we call gerrymandering.
But it's like you brought up the other day. Now, when you're talking about the voting for president and the electoral college, here you have it. The states that, I think it was Maryland, right? That was their case. They've gone back and forth as far as who they've supported for president. And they're like 53% Republican, I think it was, and 40% Democrat. Yet because the Republicans drew the lines, 77% of the seats in the state legislature are being held by Republicans. So how can that be fair?
That was a good number recall.
Thank you.
That was impressive.
How can that be fair? Half of our state is divided 50-50, yet our representation is 75%, 25%. How is that not showing that there's a bias in my representation and my First Amendment rights?
Well, see, that's the thing. I think,
and my voting rights. I'm not being represented according to the partisan stuff, which is what we're talking about, partisan gerrymandering. It's 50-50. Yet in my state, I'm 3 times as likely to be represented by a Republican because it's 3-1.
I think.
And it should be split based on the political party.
Well, I've got
another whole counter argument to take the other side, but that's off of your response. That's what I'm going to say.
I think people
how can that be legal?
Well, and maybe it shouldn't be. I think
but the Supreme Court says it is. The Supreme Court says it doesn't violate the Constitution.
Right.
How does that not violate the Constitution? That's not equality.
But that's the point, I think, that's so important about the Supreme Court, that I think we often, and this is an education thing, like so many other things, right? Mm-hmm. That I think that people sometimes misunderstand, right, what exactly the court does and what it does differently in particular instances.
Right.
Because it's easy to say, and I'm sure there's a lot of people out there right now who are saying this, the Supreme Court's saying that gerrymandering is right and that it's the way things should be and it's okay to gerrymander. No, they're not. They're saying the Constitution, our Constitution, doesn't prohibit it. They didn't say that's right. They didn't say that that's the way it should be.
It was a 5-4 vote.
Yes.
And so you have to talk about the political makeup.
Sure.
And I understand people want to say in the purest nature, the Supreme Court is not political. But
it's made up of people.
That's a farce. Okay. Because like you said, you made the argument, we really can't talk about it because these people have studied the Constitution. They spent their entire life doing it. They've done all the reading. They know a lot more about it than we do, mm-hmm. which is a true statement, except, okay, if they've all studied it equally, how come 5 of them says it says one thing and 4 of them says it says something else. So to say that the Supreme Court's not a political group is a very hard thing to say. In the purest sense, it should be. It's supposed to be, as stated in the Constitution. But it's not. If you had because
we used to have one Chief Justice, and there was no
nobody else.
For a long time,
right.
There's one of those historical
and there's no limit,
right?
and there's no limit to the number. We don't have to stay at 9.
Right. We just,
we have.
I mean, it's like, well, we got 9, so we don't want to go past that.
Right.
But just to be clear, so people understand, there's nothing, for example, where President Trump today couldn't announce a new nominee to the Supreme Court. Now, it's widely regarded as that would be politically bad, but that hasn't stopped this president in the past, and that's not a rag on Trump. It's just any president could do that.
But FDR did that.
Right.
He tried to pack the court and they said it was unconstitutional.
Right. They said, well, you can't do that.
Well, actually what they ruled was the law that gave him the power to pack the court was unconstitutional.
Right.
And didn't really, again, splitting hairs. They didn't really rule that he couldn't do it. It just said the law that gave him the power to do it was unconstitutional. This is a political issue because just last year with Anthony Kennedy on the court had a different ruling.
And actually have his.
And so now you replace Kennedy, or you replace, you add Gorsuch, you get rid of one of the liberal, I hate to use liberal and conservative.
I know.
But you get rid of, this switched the 5-4 vote. As I was discussing with some other people off air, this is not a surprise because you have the makeup of the court is going to take the government's not controlling the government of staying within the boundaries of checks and balances more so than they will on individual rights.
Yes.
Because the makeup of this court is going to want to separate the government because one of their beliefs when they study the Constitution is that the court is not supposed to make law. The people who voted on the side of the 5, their interpretation of the Constitution and historical interpretation of the Constitution is that the court is not supposed to end up, air quotes, making law.
Right.
So when that's the majority makeup of the court, it's not surprising that they would vote this way. But you switch one person on that court who studied the Constitution just as much as the person that they replaced, then all of a sudden they would say, no, we think this, the Supreme Court does have the right to make a decision on this and decide whether or not it is constitutional.
Well, and that goes back to,
which is, and you go back to why you care, because this totally reflects the representation that you get
the way that every law is crafted
in your state and in your right. I mean, this is the crux of the voting of the legal premise that we live under.
It's kind of important, huh?
I mean, I would argue that it's more important than the Electoral College or
anything
or, popular vote for the president.
Yep.
The president is one person who supposedly doesn't get to rule the country. But when you have, a Congress that won't take responsibility and do their job, then
when they don't have a spine,
that's what happens, is again, as I used to always explain in class, the president really is very limited in their powers.
Mm-hmm.
They have to get Congress's approval. But when Congress rolls over and plays dead, like
then you have a really powerful
now
president.
You get a really powerful president because nobody's standing up and saying, no, that's not your job.
Mm-hmm.
You don't have the power to do this. And right now we have a Congress who looks and says, oh, you're the president. Okay. What is it you want us to do for you? That's not the way it's supposed to work. I mean, if you read the Constitution, that's not the way it's supposed to work. So this is very important when you have a president who is, it's thundering and lightning. My truck is getting wet right now in the inside.
You want to go fix that?
Washing the interior. No, we're good.
Okay.
But because this is important stuff, and I know it's for some of you, it's like, but when you get to draw the lines to decide, what do you do? On who's going to be the representatives, and then that gives one group more power, not only within the state but within Congress. Then that's a huge piece. Now, the other side of it is, how do you ever draw the lines where you're not gerrymandering?
Right.
You know, I said I had the other side of it. My other conundrum inside myself is, how do you ever draw a line that's not gerrymandering? How do you draw a 50-50 line? You know, how do you draw a line that has, because let's face it, many of us, I'm not, but many of us choose to live somewhere where there are like-minded people surrounding us because it takes stress out of our lives. Because if people agree with you, then you're not constantly getting into arguments or getting frustrated at watching people or listening to people say things that you don't agree with. So as we tend then to live with people that are like-minded as we are, then how do you draw a district that doesn't gerrymander?
Yep. Well, we're going to look at some more details on that. But before we do, it's important that we take just a moment and let you know what we're doing here. TrueChat's mission is to educate people by providing honest, open, and respectful conversations. If you think that we're not getting that done, you can email ethics@truechat.org, ethics@truechat.org. And of course, part of what makes this all possible is the support of our sponsors. So we're going to take just a moment to hear from one of them. Welcome back. The Supreme Court says that the Constitution does not bar gerrymandering according to a 5-4 split along ideological lines. See, one of the interesting things about the court that Lance was highlighting from before that I think is important is the reason that we, I think, try to hedge away from politics is I do think that a big part of it is an ideological thing on issues like this. This is part of the trouble with the mainstream media is there were just a couple decisions recently by the court that were like 7-2, you know, but they don't make big press because it was mostly unanimous, you know.
Sure.
There were Democrats that sided with the Republicans and Republicans that sided with the Democrats, you know, and or the liberals that sided with the conservatives. And so it does happen. It's not usually quite this way.
A 5-4 vote.
But I think this is one of those that highlights that difference in the reading of the Constitution, where you have the more conservative-minded ones that read a more literal, you know, does it say somewhere that we can't do this thing versus a more, you know, what does the Constitution mean here type of thing. In other words, even though it doesn't say this, does this area of the Constitution suggest that this is the case type of thing? And I think what you see here is that the conservative, more literal reading, they're coming to the conclusion that, no, it doesn't say that, you know, and the other side is saying, well, it may not say that, but look, it says this here, and this seems like it means you couldn't do this, you know, even though it doesn't say this specifically. So now I think what we want to talk about is less about the decision itself and more about, okay, we have this decision. We know that a majority of Americans, right, support nonpartisan district lines. In other words, they, generally speaking, believe that gerrymandering is a bad thing and they don't want it. So I think there's two solutions because people, you know, the court decides something like this and, well, it's over. Well, no, it's not. There's just one branch of government. You know? There's lots of other options here, guys. The court is not supposed to make law if we go back to our government class, right, Lance? But sometimes we kind of let them make law by then the legislative branch not doing anything. The Democratic debates the other day, I told Lance, I thought, I'm not saying I agree with Elizabeth Warren, but I thought the point she raised was interesting is if we feel so strongly about Roe v. Wade, then why doesn't Congress just pass a law instead of continuing to, and you could get into that debate, but the point is, don't forget that the legislative branch can make a law anytime it wants right now today that says gerrymandering across the country is illegal.
Right.
Right. And then the court can take it up again and decide if there's a problem with that law. And they may not decide
and do their function, which is the court's function is to determine whether or not a law is constitutional.
Right. And I would think that based on this decision, that if a law was passed in Congress, that they would probably come down on the side of this law can stay, you know, because there isn't anything in the Constitution that we see from a conservative reading, if they're truly not political, rather just ideological, that says that you can't have a law like this, you know, because it doesn't say anything about gerrymandering. So therefore, sure, maybe not. If not, then you're looking at constitutional amendment. right? Which is a whole different beast.
But to me, I think that's where we need to go.
Yeah, I mean, that would be the preference, because then you avoid the court battles, again in the future. Well,
and if the numbers are true that it is a significant majority of people who agree on this, and, we go back to our old friend No Labels, who have taken these questions and, polled people, and, it's almost 70% or higher on most of these quote controversial issues with their data. The 70% of Americans or more support one side or the other. Then why can't you get, the constitutional amendment passed and then take it out of the court's hands and take it out of people's hands? Much like we did, I hate to bring it up, but it's history, much like we did slavery. It doesn't surprise me at all that we're having these kind of discussions about gerrymandering or the right of a woman to choose when you had the courts have to make the decision. Because if you study American history, and again, when you study history, sometimes you have to study it more than just in your lifetime. So people are like, well, this never happened in my lifetime, so this is brand new. And then you point out, well, no, it happened back in this decade, or it happened in this century, or it happened in this century. And they're like, oh, wow. Well, and that's why when you make it just a law and you let the court have a say so, when the court changes, their interpretation of the same law changes. And that's what we're running into. People have spent, most of their life or their entire life living under this set of laws, and they don't understand, well, how can that change? That's the law. Law means it's going to stay that way all the time. Well, not if you're dealing with a constitutional issue, because when you change the makeup of the court, they can interpret the law differently. Yep. And we teach that, or we should teach that in the school system, in government class, when you talk about strict interpretation of the Constitution or a loose interpretation of the Constitution, and I think we do, but until it happens like this, people then, just like talking about the Electoral College, they don't get it. It's not until something happens outside the norm that they're like, well, what is that going on? Yeah. And then you remind them, oh yeah, I kind of remembered that from school.
Well, that's the frustrating thing about the media.
But it never happened.
Is they have an opportunity right now.
Because they went to school too and they don't remember it.
I know.
I'm not to get in, we're not going to media bash too much, but they're just talking heads. They don't really know any more history than anybody else, which is why it's interesting when they bring on a historian, somebody or a columnist, like a George Will, or like, who's the guy on, Will's conservative. Who's the guy that's on MSNBC? They bring in, he writes books and he writes presidential history.
Because then you have somebody that really knows
John Meacham, and they bring up the historical context, and it's like, yeah, and they're not really being political at all. They're not, they have maybe their private life, they have it, but as a historian, this is what happened, folks.
Right.
This isn't new. This isn't different. It's maybe been 75 years, or maybe been, 200 years since this happened. But it's all accounted for in there, and the talking heads in the media go, oh, I didn't know that. I forgot that from my government class. They're just like everybody else. If you don't live it, if it's not a part of your daily routine, you just go by it. And that's where, if you really want to make the difference, like you said, it's the constitutional amendment, because with all the amendments, there's only one that's been taken out that's ever been put in that's been taken out. Yep. So once it gets in the Constitution, there's a lot more likelihood that it stays than if you just pass a law and then the dynamics of the court change. The dynamics of the court changes a lot faster than getting a constitutional amendment out of the Constitution.
Yeah. And just for those who probably don't remember the specifics of how the Constitution can be amended, part of why it doesn't happen very often, right, Lance, is because Article 5 spells out that the Congress, whenever 2/3 of both houses shall deem it necessary, right? So the House of Representatives and the Senate, 2/3 propose amendments to the Constitution, or on the application of legislatures of 2/3 of the several states, shall a convention for proposing amendments, which in either case shall be valid to all intents and purposes, as part of this Constitution when ratified by the legislatures of 3/4 of the several states or by convention in 3/4 thereof. What does all this jargon mean before I continue to go on? Basically, you tell me if I'm
Go ahead, boss.
stepping out here, is if the two houses of the legislature say that we need a constitutional amendment, then a convention can be held to consider said amendment. Right. Or if 2/3 of states want a convention.
3/4. No.
Well,
want the convention. 2/3 of the state can call for a convention.
In either case,
yes.
3/4, 75% of the states have to ratify whatever the amendment is passed at the convention. So this is why it's confusing to people, I think, because you've got these different. Basically, the point here is just to have the convention, you got to get 2/3 of either both the House and Senate or 2/3 of the states to say they want to do that, right? To have this place where we're going to vote on whether or not to put the amendment forward. Then we have this, we put the amendment forward, maybe, right? And maybe we don't. We have the convention, we put it forward. Then it goes to the states who have to say, we're okay with this. And you got to get 3/4 of them to say it's okay. And that's why it's so tough, because getting 75% of the states to ever agree on something is difficult, because that's kind of the point of this nation is we are this union of different states with different ideological backgrounds and different perceptions on things. And so that is a big challenge. It goes on to say that provided that no amendment which shall be made prior to the year 1880 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of equal suffrage in the Senate. So part of what they did is limit slightly what amendments could be passed, particularly when it contains to representation in the Senate, because this was a small state concern of, you're going to do this thing, and then you may just amend the Constitution and take away our voting rights in the Senate because you'll have an outsized power. And so that was one of those part of that compromise that Lance has talked about before, where the small states said, no, we're not okay with you just being able to strip away our power whenever you feel like it.
Well, and if I remember correctly, and I'd like for somebody to check me here because I'm talking without a device here. The last one I remember is the Equal Rights Amendment. It went to the states, and it was back in the 70s, and the ERA Amendment.
1972, I believe.
And the time ran out because with the amendment, there is a time limit for which the 3/4 of the states to ratify. And I think it had, I want to say 35, maybe somewhere in the 30s of the states ratified it, but it didn't get to the 3/4 number in time, and it just died on the vine.
It began in 1972, and through 1977, the amendment received 35 of the necessary 38 state ratifications with wide bipartisan support, including that of both major political parties, both houses of Congress, and Presidents Nixon, Ford, and Carter. Mm-hmm. The ERA seemed destined for ratification until Phyllis Schlafly mobilized conservative women in opposition. These women argued that the ERA would disadvantage housewives, cause women to be drafted into the military, and to lose protections such as alimony, and eliminate the tendency for mothers to obtain custody over their children in a divorce case. And basically, that's the point. 38 of the 50 states, have to agree in order to change the Constitution. And that's a tall order.
But that's the last one that I remember. So I don't know if I'm hoping I'm historically correct. I'm really impressed with my brain that I remembered the number 35. But that was the last one that I remembered that was out there. And so there's, there are times in history where just because you get the convention or you get Congress to agree to draft an amendment and send it to the states, it doesn't mean that it's going to be ratified, because that was the last one, the 27th Amendment.
The 27th Amendment to the United States Constitution prohibits any law that increases or decreases the salaries of members of Congress from taking effect until the start of the next term.
Right. You can't vote yourself a raise.
That's right.
Yeah. And that one passed. Everybody, that was part of the term limits and all of that argument back in. When did that pass? Now, was that in the 80s and 90s? Now people are going to say, well, what kind of historian are you? But
I know. It's hard to keep it all right. It was submitted by the first Congress. It's also dubbed the Long Last Amendment.
Oh.
Because it is not only the last amendment to be added to the Constitution, the most recent, it's also the oldest amendment ever proposed. It was submitted by the first Congress to the states for ratification on September 25th of 1789, along with 11 other proposed amendments, while 10 of the 12 proposals were ratified in 1791 to become the Bill of Rights.
Yes.
What would become the 27th Amendment and proposed congressional appointment amendment did not get ratified by enough states for them to also come into force. The proposed congressional pay amendment was largely forgotten until 1982, when Gregory Watson, a 19-year-old sophomore at the University of Texas at Austin, wrote a paper for a government class in which he claimed that the amendment could still be ratified. A teaching assistant graded the paper a C, and an appeal to the professor, Sharon Waite, failed, motivating Watson to launch a nationwide campaign to complete the ratification. The amendment eventually became part of the United States Constitution effective May 5th, 1992, completing a record-setting ratification period of 202 years, 7 months, and 10 days.
Very interesting. Okay.
Hey, next time, Lance, somebody tells you that a 19-year-old can't do anything,
there you go.
He got the Constitution changed.
That's right.
I'd say that's pretty significant.
That's a significant event.
Yep. There you go. So evidently that kind of tested this idea that there's a time limit on ratification. It's, again, I think one of those things that's assumed, but that's part of why this new effort for the Equal Rights Amendment to be ratified has recently gotten underway. When you go to search it, it says Equal Rights Amendment 1972, Equal Rights Amendment 2019.
Okay.
Because you've heard some of the presidential candidates, including in the debate recently, say that they want to get that ratified. They want to advocate for that to get done. So interesting. But there you go. Little historical perspective. So we gave you the little synopsis on the Supreme Court's decision. I think the question of, if we don't like this, there's a process, Lance.
Sure.
Right? I mean, we can do something about it. We can change the Constitution. We can pass a law. There's other stuff. We don't have to just say the Supreme Court said this and now it's over.
I guess we haven't said it in a long time, but the government works for us.
Right.
If
we want something changed, it can be changed.
It's our government, of the people, by the people, for the people. It's a phrase that we all say very quickly, but we forget, well, the people in Washington, they're not letting me. Whoa. We control that, folks. I mean, if we want to. The problem is we don't get all of our ducks in a row. We don't get our arguments coherent. We don't get enough support and take them on. They work for us. It's not where we need to sit back and say, well, there's not much we can do. I'm just a single individual. That's the whole point, folks, of where we live, is that we are in charge. But we have to get people to agree with us. And that's the bottom line. And it can be done.
Yep. That's the real challenge, is remembering that we ultimately do have it. And part of the reason that gerrymandering, I think, is something that Lance and I feel so strongly about is because it is one of those things that is an attempt by those in power. Okay. Forget the party thing for a minute, by those in power to stay in power. Okay. It has little to nothing to do with those of us here at the bottom, right? Those of us not in power, not Democrat, not Republican. It has to do with them wanting to keep their power. And they want to do that in the easiest way possible. And that means drawing districts that keep Democrats in power and Republicans in power consistently, instead of letting what we know to be the true will of the people swing back and forth more often than it does. There should not be a district that is, 40 miles long and is 2 miles wide. Something's not right about that. It's really hard to make the case that was drawn to be fair, and that people, over a 40-mile stretch, 2 miles wide, are all going to actually have anything in common is probably because they specifically tried to find people who thought the same, and oftentimes the areas we live in aren't quite that simple, but it's up to you to decide. You want to change it, right? Contactingcongress.org, Lance. We haven't said it in a while, but
there you go.
Super easy. You go there, you put in your address, and it says, boom, here's your representative, here's your senators, here's how you get in touch with them. It's that simple. Let them know that this matters to you, and look at presidential candidates maybe who are talking about the Equal Rights Amendment. What do they have to say about it? Are they for getting that passed? Are they for getting rid of gerrymandering? Ask them.
There you go.
The more that we talk about it, the more that those in power are going to want to stay in power and thereby try to do something that we want them to do. We've challenged people to tune in, right?
Yes, we have.
How can they do that?
Well, they got to have a device.
Okay.
But once they do that, right?
They get a device.
Yeah. Or they
I got one right here.
They can borrow their friend's device.
Uh-huh.
Maybe that's how they're listening to us.
They might.
Their friend is listening to us.
They could.
So
that's how you listen, right? I mean, you
sure
use somebody else's device.
I do.
Because your device doesn't do it.
Nope. It doesn't. But you can go to Spotify. You can use Stitcher. You can use Apple Podcast or anywhere else that fine podcasts are found.
For the State of Us on TrueChat in Urbana, I'm Justin T. Weller.
And I'm Lance Jackson.
Thank you so much for tuning in. We'll see you next time. Be the change.